In this video, we're going to review some of the rules that we've learned concerning the scope of UCC Article 2. The first rule is that provisions of Article 2 apply to contracts for the sale of goods, supplementing or replacing the common law rules that apply to other kinds of contracts. For example, Section 2201 adds a requirement that contracts for the sale of goods for a price of $500 or more must be evidenced by a signed writing. Similarly, Section 2314 says that certain contracts for the sale of goods come with an implied warranty of merchantability. Second rule that we've seen is that the term goods includes things which are movable at the time of identification, that is, physical objects which are not real estate and not attached to real estate. Things like cars or airplanes or books. The unborn young of animals, growing crops, minerals like oil or gold if they're severed by the seller, structures or their materials if they're severed by the seller, other things which are severable from real estate like a hot water heater or an air conditioner if they're severable without material harm to the real estate, timber to be cut regardless of whether it's the buyer or the seller who's going to cut it, and future goods, things which don't fit into the 7 categories at the time but will in the future meet the definition of goods. The term goods does not include anything not covered by the preceding definition, like real estate or services, and 3 items expressly excluded from the definition: money in which the price is to be paid, securities, stocks and bonds, things like that, and things in action, meaning legal claims or legal rights, like a copyright or a contract claim. Those things might be capable of being sold, but they're not governed by Article 2. A sale of goods is a transaction in which title to the goods passes from the seller to a buyer for a price. This definition excludes leases and bailments, because title doesn't pass, and gifts, because there is no price. The term contract for sale includes both a contract to sell in the future, where one party might promise to pay in the future, or another party might promise to ship or make goods available in the future, and also a present sale, such as an over-the-counter sale, even though in a present sale the parties might not be making any promises to do something in the future. A hybrid contract is a contract for the sale of both goods and non-goods, like services. Most courts will apply Article 2 provisions to a hybrid contract if the sale of goods is the predominant purpose of the contract. So, for example, in Coakley and Williams v. Shatterproof Glass, the court concluded that it was possible that the glass involved in the sale and installation of a window was the predominant purpose. Some courts will apply Article 2 provisions to a hybrid contract if the gravamen of the complaint concerns the sale of goods. In other words, in a contract to install goods, if the complaint is about the goods themselves, that complaint would be governed by Article 2, but if the complaint is about the installation, well, that might be governed by the ordinary rules of contracts. Final rule is that most courts will apply Article 2 provisions to a transaction that is not a contract for the sale of goods, but is analogous. So, for example, in Barco Auto v. PSI Cosmetics, the court applied Article 2 provisions to a lease of goods because it found it to be analogous. Similarly, in Zapata v. Dairy Mart, the court applied Article 2 by analogy to a franchise agreement, even though the franchise agreement was not predominantly for the purpose of selling goods. Finally, some courts take an inclusive approach to Article 2 based on policy considerations. So, for example, one of the reasons in Advent Systems v. Unisys that the court decided to apply Article 2 to a contract for the sale of software was the policy reason that software is sold much like other goods. Now, how do these rules apply in actual cases? Well, it's very important to understand that the parties may not be neutral about the question of whether a contract is governed by Article 2 or the common law. Parties may argue about whether Article 2 provisions govern a contract because the issue may determine the availability of claims, defenses, exceptions to defenses, and remedies. Here are 3 examples. The first one involves the availability of a claim. Suppose that a plaintiff sues the defendant claiming that the defendant breached an implied warranty of merchantability. the defendant might argue in defense that Section 2314, the UCC provision that creates the implied warranty of merchantability, does not apply, and therefore that there is no implied warranty of merchantability because the particular contract was not a contract for the sale of goods. We saw an example of that argument in the Coakley and Williams v. Shatterproof Glass case, where the defendant argued that the contract to sell a window and install it was not governed by Article 2. A second example involves the availability of a defense. Suppose the plaintiff claims that the defendant made a promise and didn't keep it. The defendant's defense in our hypothetical is that the promise is not enforceable because the requirement of the statute of frauds in Section 2201 are not satisfied. There's no writing, or it doesn't specify the quantity, or whatever else might be the problem. The plaintiff's reply might be, well, Section 2201 does not apply because this is not a contract for the sale of goods. Therefore, there is no writing requirement or signature requirement. That's the argument that was presented in the Advent Systems v. Unisys case. A third example concerns the availability of an exception to a defense. Suppose that the plaintiff claims that the defendant broke a promise to keep an offer open. And suppose further that the defendant's defense is, well, there was no consideration for my promise to keep the offer open. The plaintiff might reply, well, no consideration is needed because of the exception for firm offers in Section 2205. The defendant then might respond, well, Section 2205 does not apply because this is not a contract for the sale of goods. In other words, whether something is a contract for the sale of goods is often an element of a particular claim, defense, exception to defense, or remedies. And so it's something that the parties will argue about, just like they might argue about any other element of a rule. That's what we saw when we talked about the scope of Article 2.